तौर पर एमनेस्टी का इस पर कोई रुख नहीं है, ना तो उस पर ये खनन होना चाहिए या नहीं होना चाहिए, इक्तिसादी तरक्की का मॉडल क्या हो या ना हो, उस पर भी हमारा कोई रुख नहीं। हाँ, मुखालफत हमारी ये है कि कोयले को निकाला जाए तो वो गैर जिम्मेदाराना तरीके से ना किया, और ये यहां पर हो रहा है गैर जिम्मेदाराना, ये एक गलत बात है ना। हम नहीं मानते कि ये सवाल इक्तिसादी तरक्की बनाम हकूक इंसान का है। डेवलपमेंट का मानवाधिकार दुश्मन नहीं, एक हिस्सा है। इस सरकार का जो नारा है सबका साथ सबका विकास, इस हकीकत को पहचानता है, शायद हमेशा इसका एहतराम नहीं करता। इस रिपोर्ट के जांच परिणाम हमने राज्य और केंद्र सरकारों और कोल इंडिया लिमिटेड को दिए। उनकी टिप्पणी या तनकीद हमने मांगी, वहां से कोई जवाब नहीं मिला। मेरे ख्याल हमने 3 मंत्रियों को ये रिपोर्ट को दिया है, ओरम साहब को, दवे साहब जो के नए पर्यावरण मंत्री हैं, और तोमर साहब को। अब मेरी गुजारिश है कि शैलेश और अमरुणा आपको तफसील से ये रिपोर्ट
So much of this report is about how the coal mining that has happened in these 3 mine areas actually violates Indian domestic law and India's obligations under international law. So I just spent a few minutes outlining what exactly these legal requirements are and problems with both the laws themselves and the way they've been implemented. Now, when it comes to land acquisition, prior to 2014, the land acquisition around the country was carried out under a colonial law called the 1894 Land Acquisition Act. This was an antiquated law which had a complete lack of safeguards and a very loose definition of the public purpose for which land could be acquired, which meant that millions of people were uprooted from their homes without being adequately consulted or rehabilitated or even received remedy. This law contained no provisions for consulting communities, far less seeking their consent or even assessing the human rights impacts of land acquisition. In 2014, a new law was enacted, the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Law. I just call it the New Land Acquisition Law, which was a vast improvement over the 1894 Act. Now, this law actually required the prior consent of the concerned Gram Sabhas in scheduled areas before land could be acquired. Scheduled areas are certain areas specified under the Constitution where scheduled tribes live. The new land acquisition law also mandated that before land acquisition could take place, a social impact assessment had to be carried out, which means an independent study by experts which actually consulted communities to understand the impact that the acquisition would have on their lives. The main flaw with this law was that it expressly exempted land acquisition under 13 other laws from its ambit. And one of those laws which was exempted was the Coal Bearing Areas Act. What this means essentially is that when it comes to land acquisition by the government for coal mines run by the government, like Coal India Limited, it's as if the new law was never enacted. So if your land is being acquired for a mine run by Coal India, it's like the 1894 Land Acquisition Act never went away. The CBA is identical to the Land Acquisition Act in many ways. Under the Act, when the government is satisfied that land can be acquired and that coal can be obtained from a certain area, it declares its intention to acquire the land in a government gazette, which I'm sure that a lot of us would not ever have seen, let alone communities in rural villages whose lands are being acquired. There is no requirement to directly inform communities or consult them in any way. Anyone who objects to this acquisition has to file objections within 30 days to the government, and then the central government issues another declaration, again in the official gazette, saying that all rights are now vested with the government, and then the government vests these rights with Coal India Limited. Needless to say, this Act and the requirements for notice under the Coal Bearing Areas Act fall well short of international standards and what actually constitutes adequate notice of emissions. Now, there are also certain other laws, and we have people here in the audience who have been instrumental in drafting those laws, which were enacted to protect Adivasi rights, which unfortunately are extremely poorly implemented. One of them is the PESA, or the Panchayat Extension to Scheduled Areas Act. The provision which is relevant for us is one which says that whenever the government wants to acquire land in scheduled areas, it is supposed to consult the local Gram Sabhas. It is also supposed to consult Gram Sabhas before rehabilitation or resettlement decisions are taken. As you will see, and Aruna will explain, this requirement was flouted in all the areas that we examined. In fact, all the Coal India subsidiaries, SCCL and CCL, have actually claimed in court that the PISA does not apply to them because they acquire land under the Coal Bearing Areas Act. So even though there is a law in the books which mandates consultation with communities, these companies claim that it doesn't apply to them. And of course, state governments have made it easier for them to claim this by not notifying the rules for the implementation of this act itself. Another important law is the Forest Rights Act, which was enacted to enable Adivasi communities to gain legal recognition of their rights over their lands. Now, all development projects have to get something called a forest clearance from the Ministry of Environment and Forests. And under the Forest Rights Act, to get that clearance, state governments have to obtain the consent of Gram Sabhas before forest land can be destroyed. Now, this is not necessarily land that is owned by anyone. This is common forest land, and if that is to be destroyed or diverted for industry, you have to obtain the consent of Gram Sabhas. And these Gram Sabhas, there are certain technical requirements, like they have to be